Okay, well, good morning, everyone. Welcome to today's webinar on financial abuse, debt and insurance, which is brought to us by the Financial Rights Legal Centre. My name's Penny Sullivan. I'm one of the sector sustainability team here at Community Legal Centres Queensland. Before we get started, I'd like to acknowledge the traditional owners of the land on which we are holding this webinar today. In Brisbane, we're on the lands of the Turrbal and the Yagara people, and I wish to pay my respects to their elders, past, present and emerging. I acknowledge that Aboriginal and Torres Strait Islander people are the original custodians of this continent and have lived and learned on these lands for countless generations. As this webinar is being viewed by people across Queensland and Australia and is being presented from New South Wales, I'd also like to pay my respects to the traditional owners of the lands throughout this country and extend a very warm welcome to any First Nations Australians listening today. So we're delighted to have Claire Curry and Rebecca Wong, together with Annabelle McConaughey from the Financial Rights Legal Centre, who are going to explain financial abuse, provide some practical steps that can be taken to help victim survivors untangle their situation, take us through available legal remedies and defences, including external dispute resolution mechanisms, and finally, to outline options that can assist clients facing issues of financial abuse. I'll let the team from Financial Rights tell you a bit more about themselves when I hand over in a moment, but just a few items of housekeeping to cover. Today's webinar is being recorded and we'll have that recording available to download later today or tomorrow. The PowerPoints and other materials have been emailed out yesterday to everyone who registered, so they're available to download from our website and from the handout section of the control panel. There are two ways you can ask questions. You can press the button that looks like a hand, which you've already done for our sound check, which was fantastic. So we'll see the hand go up at our end and we can unmute you so you can ask your question via the microphone, or actually our much preferred method is if you could type your question into the question box and we'll read your question out. So we'll check in for questions around the halfway point of the webinar and then again at the end of the presentation. So feel free to type them in as you think of them. So I'm going to hand over to Annabelle now to formally introduce Claire and Rebecca, and I'll talk to you again at the end of the session. Thanks so much, Annabelle.
Thank you very much, Penny. I hope everybody can hear me clearly. I would just like to acknowledge and pay respects to the traditional owners of the land where Financial Rights is based. As Penny mentioned, we're here on the land of the Gadigal people of the Eora Nation, and we'd like to pay respects to their elders past, present and emerging. I'm joined by two of our solicitors today who are going to take you through domestic and family violence, debt and insurance issues. But I'm just going to briefly explain who we are and what services that we can offer. I'm the Community Legal Education Officer with Financial Rights Legal Service. So I need to say that this presentation is for information only, and obviously you must seek legal advice if you've got any particular circumstances that you want to go through with someone. Now, we're a community legal centre and we have 5 telephone advice lines that we offer Monday to Friday. We're going to go through some credit and debt and insurance issues with you today, and those are 2 of the legal advice lines that we offer. Currently, we offer our credit and debt legal advice line not just to consumers in New South Wales but also in Queensland. So you are able to provide the top 2 telephone numbers if you have a credit and debt legal or insurance legal issue to consumers, and we've got a dedicated dial 1 if you have a domestic or family violence related insurance query, so that we can prioritise your call if it comes through on the Insurance Law Service. Those lines are available between 10 and 1, but we also have other telephone services that are available between 9:30 and 4:30. And the one that's probably most important for you is a caseworker hotline. So if you do want some secondary consult advice or if you'd like to make a warm referral for one of your clients, you can call us on the O2 number from Queensland, and we'll be able to take those calls. Now, the reason for that is that we've got some funding which takes us through to the end of the financial year at the end of June 2022, which means that the normal service that we are able to offer to New South Wales consumers, we can extend to consumers from Queensland. And for any individuals who've been impacted by COVID, and particularly those who have suffered domestic or family violence, we'll be able to support those. Could you just note that at the bottom of this slide, this isn't in your handout, but if you do have any queries, you can also email us on the info@financialrights.org.au email and reference this presentation so that we know where you've got those details and where you're coming from. But please feel free to use that if you've got any queries after today, or if you would like to make a warm referral. Now, I'm going to introduce you, I'll sort of hand over to Claire to start off the presentation, but what we wanted to do first was run a quick poll just to get an idea of the experience in the room. So I'll hand back to Penny, who'll run that, and then I'll hand across to Claire and Rebecca to take you through the information. And I'll let Claire and Rebecca let you know some of their experience when we get to their piece of the presentation. So Penny, over to you.
Thanks, Annabelle. Okay, so we're going to have a go at this poll now. Hopefully this will work, everyone, so bear with me. There we go. So the poll is up. How many of your clients have debt issues? Could you please go ahead and select one of those responses? And we'll just give a little bit of time for everyone to put their responses in. Things are going up. Okay, we're getting lots of responses in. That's fantastic, everyone. Thank you. Terrific. Okay, just another few seconds for the last ones to come in if there's any more. Okay. Thanks so much, everybody. Okay, so we're going to share the results of that poll now. So, Annabelle, you can see there that we've got a lot of people on the webinar today who've got clients who have debt issues. Some people who are seeing some clients, and then there's a couple of other responses there. So some people are not in a client-facing role. So hopefully that will be helpful to Claire and Rebecca as we go forward to understand just the profile of who's with us today. So thanks very much. I'll hand back to you now, Annabelle.
Thanks very much, Penny. Look, this is really interesting. I'm doing the screen sharing, so I didn't get to see the poll results, but hopefully Claire and Rebecca have been able to see those just to get a feel for who's out there in the audience. I will be driving the slides, so bear with me if there's a bit of a delay between Claire or Rebecca working through their material, and also there will be some case studies that we touch on to give you some idea of some of the cases that we do see coming through. But let me hand you across. I'll flick the slide and hand you over to Claire.
Good morning, everybody. My name's Claire Curry. I've been a solicitor now for about 18 years. I think I've been at Financial Rights for probably about 11 of those, in between 3 kids. So yes, it's a great place to be. So this slide is just a brief outline of what we're going to be covering today. So we're going to look at what is financial abuse. We're going to cover or look at some of the legal defences and how you can assist your clients. We're going to look at some remedies and some case studies. We'll cover bankruptcy briefly and family violence and insurance. And we'll also talk to you about when to get some specialist legal advice. Annabelle, thank you. So why are we covering this topic today? How prevalent is it is financial abuse in Australia? Well, within the past few years, there has been increasing public awareness and discourse about family violence in Australia. Advocates like Rosie Batty have done incredible work to bring public attention to issues that for so long have been kept behind closed doors. The statistics are quite sobering. 11.5% of Australians have experienced financial abuse, but women are significantly more likely to experience financial abuse. It stands at 15.7% compared to 7.1% of men. So that's sort of more than double the number of men. That being said, it's also important that we don't exclude male victims from the conversation. Our financial counsellors recently raised at a casework meeting that male victims are often required to provide more evidence than female counterparts. So we need to be sensitive to and mindful of some of these additional hurdles that male clients who are victims of financial abuse may face. Research shows that there is often a spike in violence against women during major crises and disasters. During previous natural disasters including flood, drought and bushfires, banks observed delays in reporting financial abuse as people secured their immediate needs and addressed their safety first. Banks have observed a spike in reports of family and domestic violence, as well as changes to the way customers reported it. For example, there has been an increase in usage of alternative contact methods such as SMS and web chats. This suggests that people did not feel safe having conversations with support services during recent lockdowns. So what is financial abuse? Financial abuse is a form of family violence that negatively impacts a person financially and undermines their efforts to become economically independent. Financial abuse can include controlling behaviour that denies a person financial autonomy, for example, access to finances, bank accounts and financial records, or the ability to work, study or access benefits. It can be withholding or threatening to withhold financial support necessary for the maintenance of a partner or a dependent child. It can be coercing a person to relinquish control over their assets, take out a loan, credit card, or guarantee a loan in their name for the benefit of the controlling partner, or to guarantee a loan. It can also be using control of finances or debt to prevent a person leaving a relationship. Financial abuse is primarily about power, control, and manipulation of an individual. Financial abuse often occurs with other forms of violence, including physical violence, intimidation, and controlling behaviour. The consequences of financial abuse could be that the victim has insufficient funds to meet basic needs, homelessness, the prospect of long-term financial hardship, being forced to pay all joint loan payments, and potentially acquiring a poor credit history from a joint loan. It may also result in a person being prevented from engaging in regular employment. The abuse is generally long-term and may continue after an individual has left an abusive partner. We're going to look at some important terms. I think just based on the poll that was just carried out, that I will go into a little bit of detail about the terms that you will find are used quite often. They're relevant when we talk about financial abuse and debt, and we should be aware of them. And I'm sure a lot of you are, familiar, but we will discuss those. So we're going to look at a co-borrower. If you are a co-borrower on a loan, you are jointly and severally liable. So this means that you're responsible for the entire debt, including interest, default fees, enforcement fees, if the other person doesn't pay, not half. So I think that's a common mistake that some people make. If you're a guarantor on a loan, you're responsible for the entire debt if the principal borrower does not pay. So that includes interest, default fees, enforcement fees, or the amount up to the guarantee if it is a limited guarantee. For larger loans, you may have to provide security like your home. Lenders want guarantees when they are not confident the borrower can or will pay, or they don't have enough security to cover the loan. Guarantors have no ownership rights in relation to the property or the goods purchased with the loan that they guarantee. The next lot of words relate to small business. Business owners are often required to provide personal guarantees to get a business loan. A personal guarantee requires you to pay a loan personally in the event of default. Directors are also personally liable when businesses are caught trading insolvent. So with a credit report, the privacy law allows lenders to provide information to credit reporting agencies about your borrowing history. This may be a default listing or a court judgment or a RHI. This can then affect your ability to borrow money in the future. I'm sure you're all familiar with what a mortgage is. It's a type of loan where a security interest in real property is held by a lender as security for a debt, so I won't go into too much detail about that. With a consumer lease, it's a contract for the hire of goods where the consumer has no right to purchase the goods. Commonly consumer leases are available for consumer goods such as fridges and washing machines and TVs, that kind of thing. So, is the victim of financial abuse liable to pay? Unfortunately, the answer is not always straightforward. The victim of financial abuse is not always automatically liable to pay for their partner's debts, whether they be married or not. If the victim has signed a contract as a co-borrower or a guarantor, or was a director or partner in a small business, or is the recipient of the service, then they may be liable for the debt. It will be dependent on, numerous things. So what can that victim do? If the client has signed the contract and the lender or service provider knew or facilitated duress, there may be a way out. So duress is often argued with undue influence and unconscionable conduct. Undue influence is more focused on the quality of the consent of the weaker party. There's an inequality of power between the parties, which results in the weaker party entering into a contract with a dominant party. Unconscionable conduct is focused on the quality of the offending party, generally understood to mean conduct which is so harsh that it goes against good conscience. Conduct may be unconscionable if it is particularly harsh or oppressive. A limitation here will be trying to argue that the credit provider knew or ought to have known about the duress or the unconscionable conduct. There may be other legal defences that may be available to the client. If we look at unjust contracts, it's defined in the NCC under section 76 subsection 8 as including unconscionable, harsh or oppressive. It's defined very widely. There's a range of factors that can be considered to determine whether a contract is unjust. These include whether the consumer received independent legal advice, whether the contract was explained to the consumer and whether they understood that explanation, whether unfair tactics or pressure was used on the client, and whether the credit provider explained the consequences of the contract to the consumer. As with arguing duress or unconscionability, unjust contract has the same limitation as requires the credit provider to know or ought to have known, so their knowledge is definitely a factor. And this may be a barrier to raising it as a defence. The remedy is discretionary and will vary depending on the circumstances of the case. As a general rule, if the consumer received a benefit, they will generally need to repay the benefit, and the consumer should be put back into the position they should have been in but for the unjust transaction. With an unsuitable loan, credit licensees must not enter into a credit contract with the consumer if the credit contract is unsuitable for the consumer. The loan is unsuitable if the consumer could not repay the loan or only with substantial hardship. To work out if a loan is unsuitable, the credit provider has obligations to make reasonable inquiries about the consumer's requirements and objectives and their financial situation, and then take reasonable steps to verify a consumer's financial situation. The remedy is generally that the consumer has to repay the benefit received and have the interest, fees and charges waived. When we look at a co-borrower versus a guarantor, the NCC prescribes certain information that must be given to a guarantor, that includes prospective guarantors, before signing the guarantee. A guarantor must be given a copy of the credit contract and an information statement. There is a list of requirements that are outlined in the NCC. Credit providers often try to avoid taking guarantees and may put someone down as a co-borrower, as it's easier for a guarantor to challenge a guarantee. So if you have a client who is a co-borrower but didn't receive any benefit from the loan and the credit provider knew or should have known, you could argue that they should have been a guarantor and not a co-borrower. If you can successfully argue that the client was a guarantor and not a co-borrower, and the credit provider did not comply with the NCC, the guarantee may not be enforceable. You can also look at the statute of limitations and the Limitation Act and how it places time limits on the rights of a creditor to bring an action for the recovery of old debts. In most cases, a creditor or debt collector must recover the debt or commence court action to recover the debt within 6 years of the date on which the debt first arose, the date you last made a payment, or the date you acknowledged the debt in writing. So the 6 years runs from whichever event occurred last. If the creditor does not commence court action within the 6 years, you will have a complete defence to the debt. There's nothing there preventing the creditor from commencing court action, but it's up to you to raise the Limitation Act defence if it applies. You should also consider whether you can raise the Limitation Act defence if your client is a victim of financial abuse. If any of these apply or you're unsure, then get specialist legal advice and feel free to contact us. If there's no legal defence, or if there is a legal defence you can argue, you may decide that based on the circumstances of the client, the most ideal outcome would be to request a compassionate release from the debt. And we'll discuss this further when we have a look at remedies. So what documents will you need? It's likely that clients won't have all the documents that you need. So you can request these on your client's behalf, obviously with their consent, and you'll usually need a written authority. So the things that you'll need are an application form, an unsuitability assessment, supporting information that was relied on, a signed credit contract, credit-related insurance contract, any notices given under the NCC like a default notice, any statements, and a payout figure. Under the NCC, the lender must provide these within a certain time frame. So, for example, a copy of the credit contract should be provided by the lender 14 days from the request if the loan was given less than a year ago. If it was more than a year ago, the lender has 30 days from the date of the request. We have a fact sheet on our website that you can refer to. It's called "How Do I Get Copies of My Loan Documents?" In your letter requesting documents, you should always include a request for a hold of any enforcement action to allow time for the client to get advice after the documents are provided. We would generally ask for 30 days after the documents have been provided. So, what should what sort of things should you be asking your client? You need to ask your client about their interactions or the lack thereof with the credit provider and staff, and even a broker if that's relevant, at the inception of the loan and throughout the life of the account. Things to look at are who gave the instructions. Could your client be seen or heard to be taking instructions from another party? Other things that are relevant are silences. So did your client remain silent while the other party did all the talking? Were they fearful, unfocused, or withdrawn? Was your client confused? Did your client appear reluctant to talk about what the funds being borrowed would be used for? Did your client disclose the existence of an ADVO or other protection order? Also, something else that you consider are the issue of interpreters, whether the one was required, obviously required and not used, or, was your client afforded that opportunity?
Thank you for that, Claire. Look, before we move into sort of outcomes and remedies, if anybody does have any questions that they'd like to pop up in the questions section, feel free to do so. Penny, I don't see anything there at the moment unless I've missed something.
I've got one question that's popped up here, Annabelle. So it's really about the hotlines. So this is from Tricia. She's a financial counsellor with a CLC who works from Queensland for clients nationally, with WA clients dominating the referrals. If we are seeking solutions for these WA clients, does your hotline extend to these scenarios?
Now, hang on, I'm going to go back to the slide right at the beginning. We would certainly be able to take a call on our caseworker hotline for Trish to be able to run through the case that she has and whether or not we would be able to help. In the case of Aboriginal and Torres Strait Islander clients, all of our services are national. So in that instance, yes. But I think for insurance issues, if they impact on anyone, any of our insurance issues are covered nationally. But for credit and debt issues, it may be limited to New South Wales and Queensland. But Trish, because you're based in Queensland, give us a call anyway, so that we can just run through that and whether we are able to help.
Great. And Annabelle, we've had Nadia from the Consumer Credit Legal Service in WA say that they can assist with those issues, not insurance, but...
Oh, fantastic. Yeah. So the insurance one, definitely us. But if Nadia is based in WA, that may be a suitable referral there.
Yep. Great.
Annabelle, I was just going to say that in those circumstances, if we aren't able to help, that we would probably try and give a useful referral. So that was really good. Now we know who we can refer to.
Yes.
Yeah. Oh, no, that's great. Nadia, perhaps, yes, get in touch with us and then we know we can refer onwards. That's always good. Look, well, if there's nothing else just at the moment, what I'll do is hand over to Beck and move on to some outcomes and remedies that are available.
Thanks, Annabelle. So hi everyone, and thank you for the opportunity to present today. My name's Rebecca Wong, and I'm one of the frontline solicitors at Financial Rights. So I may be one of the people you first speak to if you call on one of the hotlines. I've been at Financial Rights for 4 years, and I previously trained at Redfern Legal Centre and then private practice with the family law focus for 3 years. So we're going to move now into outcome and remedies and touch on issues such as credit reporting, the banking code of practice, and how external dispute resolution can help. Keeping in mind the poll today, it's great that we've got such a diverse range of people listening in. Some of our material is looking at giving tips to caseworkers on options for outcomes to help with debt problems. However, we will also be looking at some broader policy considerations and updates in the family and domestic violence space. So for caseworkers, it's a good idea at the start of taking on a matter to work out what sort of remedy the client is seeking or would be able to afford. The legal arguments available to the client will also impact the outcome or remedy that can be expected. So here is a list of possible outcomes and remedies that you can consider when working out with your client a suitable remedy. Full or partial waiver, counter offer of a reduced lump sum reduced payment, refund, waiver of interest and of fees, a hold on interest and fees, severing liability, including agreement to release from liability, cancellation of account, financial hardship period or reduced or no repayments can be for 3 to 6 months, and a repayment plan. Also check the credit report for any default listing and ask for removal of disputed listing if the issue has been resolved. What to look for in the documents. This is not an exhaustive list, but are some things to look out for in the documents when raising a dispute with the credit provider. Is the income higher than the actual income? Did your client have no income or only Centrelink income at the time of application? Are debts or liabilities not listed or inaccurate? Does contact information not match your client? So for example, the partner's email or phone number were given only. Were inquiries made about your client's income and expenses? Did the lender verify your client's financial situation? So for example, did they ask for any pay slips, any Centrelink income statement, or bank account statements to be reviewed? Was there limited or no contact between the lender and your client, or was contact controlled by the partner? Credit reporting. A victim's credit report can affect their ability to obtain credit in the future and re-establish financial independence. If a financial hardship variation is agreed and complied with, the credit provider should not make a negative credit listing. See the Australian Banking Association's Family and Domestic Violence Banking Industry Guideline at section 4.11. Section 4.11 states that banks will work with a customer to review their circumstances and should not enter negative credit information if a customer is affected by family and domestic violence, so far as the bank is able to avoid doing so under the law. Where the bank is aware of family and domestic violence and a formal hardship arrangement is in place, the credit report will not reflect missed repayments for the duration of the arrangement. The effect is that the guideline broadly expects the bank to work with consumers affected by family and domestic violence and try to come to an appropriate outcome in relation to credit report and listings. We'll discuss the Australian Banking Association's Family and Domestic Violence Guideline further in the next slide. If in doubt, obtain and review the client's credit report. If there is a disputed listing, there is a process for raising a dispute to remove or rectify the disputed listing or listings. We have a fact sheet on our website on credit reporting. It sets out the process for raising a dispute about a credit listing. So please take a look at that if you would like further information. The client's credit report can be obtained for free from one of the following agencies: Equifax, Ilion, or Experian. So the Banking Code of Practice and Industry Guidelines. The Banking Code of Practice 2021 had an update that came into effect on the 1st of March 2020. It sets out standards of best practice and complements the law. The banks are bound to comply with the Code of Practice. Breaches can lead to a binding remedy or outcome being sought at AFCA. So AFCA is the Australian Financial Complaints Authority. Chapter 14, sections 38 to 41, recognize vulnerable clients as being affected by family and domestic violence and financial abuse, and set out that the bank must work with these clients to find a suitable outcome. Other sections that may be relevant are Chapter 15, Banking Services for People with a Low Income, Chapters 39 to 41 on financial hardship, and the COVID-19 special note on page 8. The responsible lending, co-borrowing, and guarantor provisions are relevant if seeking a legal remedy. For example, if the co-borrowing customer will not receive a substantial benefit from the loan, the bank has to take steps to ensure that the customer understands the risks and that they are not experiencing financial abuse. Where the customer is providing a guarantee, the bank should ensure that the customer signs the guarantee in the absence of the borrower. This is to avoid family and domestic violence situations of conflict of interest. There are two relevant guidelines which complement the Code of Practice. The second one, relating to financial abuse, looks broadly at financial abuse, and it also includes elder abuse. The first guideline is the main one for family and domestic violence. Sections relevant to caseworkers seeking a remedy for a debt include 4.10, where a customer's debt involves family and domestic violence, the bank should not on-sell the debt to a debt collector and can also consider repurchasing the debt. 4.9, financial hardship, where the bank is aware of family and domestic violence, they should take steps such as fast-track hardship requests and recognize longer-term and more flexible arrangements for managing the debt. And also 4.8, banks should work with customers to regain control of their finances and manage accounts that are held jointly, including providing advice to customers about account settings and options. So moving on now to external dispute resolution. AFCA is the external dispute resolution for financial services. So it stands for Australian Financial Complaints Authority. All consumer credit providers, the big banks and insurers are members of AFCA. AFCA is free for consumers. AFCA can make decisions that are binding upon the member financial firm. AFCA has a series of approach papers setting out how it will deal with certain types of complaints. There is one approach paper for family and domestic violence. It's called the AFCA approach to joint facilities and family violence. Some examples on page 3 of the family and domestic violence issues that AFCA can help with include the following. So when one borrower is pressured to enter a loan into a loan which is not for their benefit, or was unaware that a loan was taken out in their name, a guarantee is signed under duress, or the guarantor was misled and didn't understand what they were signing, one borrower wants to split or sever a joint loan following a relationship breakdown, one borrower is experiencing financial difficulty and requires hardship assistance, one account holder makes withdrawals or other transactions without the other account holder's knowledge or consent, and credit reporting and default listing issues. Weighing the pros and cons of going to AFCA. So some of the pros of going to AFCA, it's free and independent. It can resolve disputes quickly, especially if the complaint is fast-tracked. It's easy for consumers to self-represent or have someone help them, and that person can be a family member, a support person, or a caseworker. It's less complex than court or tribunal. Consumers can still go to court if unhappy with the AFCA outcome and they're within time. and compensation for pain and suffering is capped. Some of the cons of going to AFCA: the complainant still has to establish the complaint on the balance of probabilities. Complaints are usually won on technical arguments. Some remedies, for example, unsuitable loans, still require the benefit to be repaid. AFCA can't consider remedies on compassionate grounds. Matters going to decision can take some time for a decision to issue. And complaints are handled mainly through telephone and on the papers, so no face-to-face. And AFCA also cannot consider complaints if the monetary dispute is above its limits. And I'll just mention two other external dispute resolution schemes that may be relevant. So the Telecommunications Industry Ombudsman for telecommunication debt disputes, and the Energy and Water Ombudsman for electricity and water bills disputes. So I'll pass over now to Claire to take you through the first case study.
Okay, so we're going to have a look at the case study of Annie today. Annie was a client that our centre assisted earlier this year. So in 2013, while shopping at a big retailer, Annie's ex-husband took out a credit card in her name to purchase furniture. Annie had recently arrived from Armenia and could not speak English and was not working. It wasn't until 2014 she became aware of this credit card when she took her bank statements to a social worker to ask why the balance kept reducing. At around the same time in 2014, Annie gave birth to her second child. 25 days later, Annie and the older child, who was 2 years old, were severely assaulted by the ex-husband, and he left. Despite not owing the debt and having very little income, Annie was paying the creditor $295 per month for the past 6 years. So in September 2020, Annie was told by the creditor that the card had been cancelled and that the debt had been cleared. But shortly after, Annie received a letter demanding she continue making payments and a direct debit taken from her account. It was at this point that the social worker and Annie contacted our office. Unfortunately, we see so many people like Annie. So what were we able to do? We negotiated with the creditor, pointing out errors in the loan application form, which made it clear that Annie was not agreeing to take out this loan. We took the creditor to AFCA and we attended a conciliation. After the conciliation, the creditor agreed to refund all payments made by Annie, and they were in the sum of $7,191.19. So some of the most obvious errors in the loan application form that we identified and pointed out to the creditor were the wrong contact details for Annie, including the address and reference under reference details. It required the name of a close friend in Australia that wasn't living with her. And the reference given was actually Annie's eldest daughter, who was 15 years old at the time. The email address stated for Annie was not hers. It had never been her email address. It was actually the email address of the ex-husband. Annie was also stated as having worked full-time for 18 months, and she had never engaged in any paid employment. Under the applicant's weekly income after tax, it stated $800. Our client was receiving significantly lower income of Centrelink benefits of $650 per fortnight. And under your share of monthly living expenses, it stated $300, and Annie's actual share of the monthly living expenses was significantly higher and included $390 per month for rent, groceries for $600 a month, and utilities for $200 a month. And now Beck's going to take you through the case study of Julia. Over to you, Beck.
Thanks, Claire. So Julia's story, it's a particularly relevant one as Julia was a client from Queensland and referred to us by a refuge counsellor. Julia inherited an unencumbered residential property in Queensland from her mother. At the time, she was in an emotionally and physically abusive relationship with her now ex-husband, who exhibited a lot of control over her. A few years later, Julia's ex-husband arranged for her to sign a number of documents with a broker. The documents included what she now knows was a loan agreement and a mortgage over her property. Neither Julia nor her ex-partner could afford the repayments on the loan, as their only source of income was the disability support pension. Julia did not receive any benefit from the loan, and she only became aware of it after her ex-husband left and moved into a retirement village. When she contacted us, she was living in crisis accommodation. She was recovering from a serious illness and she had spent a lengthy time in hospital. Encumbered property was vacant, however, the mortgage was accruing interest. The ex-partner had made off with the funds, leaving her with a mortgage she was unable to repay. She was referred to us by the counsellor at the refuge. What were we able to do? We contacted the bank on behalf of Julia and raised concerns that the loan was unsuitable when it was granted. Shortly thereafter, the bank agreed to reduce the balance by $100,000 and freeze the interest for 6 months. This was a remedy that was typical for unsuitable loans, where the borrower must still repay the benefit received, although the lender loses the right to charge interest and other fees. However, the bank indicated that it had conducted an internal review and determined that it considered at least part of the loan was clearly used for the sole benefit of Julia's ex-husband. In light of the confirmation of the bank's findings and our previous instructions that Julia hadn't received the benefit of any funds, we again requested the bank review the file and consider waiving the debt in its entirety. After a further review by the bank agreed to release Julia from the entire debt of $240,000. It also paid Julia a small amount of compensation. Importantly, the bank agreed to release its mortgage over the property, meaning that Julia was back to being mortgage-free. Financial Rights advised on the deed of settlement and oversaw the restoration of the title to Julia.
Thank you. Again, a good place to pause, I think, before we move on to our last two issues in this presentation, just to see if there are any more questions that have come in, Penny.
Hi, yes, I have one here, Annabelle. It's from Rachel, and she asks, are the guidelines in the customer-owned banking code of practice similar in regard to credit listings for DFV matters?
I might throw that over to Beck.
Sorry, I didn't really understand the question. So what customer?
Yes, let me read that through again.
Neither did I. Sorry, could you guys just repeat that again?
Yeah, I can read it
Are
out.
the guidelines in the customer-owned, are the guidelines in the banking code of practice similar in regard to credit listings for domestic and family violence matters? Oh.
Okay. So I guess, yeah, there's a lot of different policies sort of going around. So each bank has their own family and domestic violence policy on their website. But then with the credit listings one, that was the one I was referring to, the Australian Banking Association guidelines. And then there's also the ABA guidelines. That's the banking code of practice. So that's the general one where banks have to adhere to the code of practice. And I think, yeah, the credit listings part of it is part of that overall one. However, individual banks also have their own family and domestic violence policies.
Thanks, Beck. So I suppose in some respects that means you have to look in two places, at the ABA Banking Code of Practice, which should cover every single bank, and then also at the individual banks' policies.
Yes. And then maybe also like the AFCA approach paper as well. So it's a few different places to look at.
So Rachel just provides some clarification there, and she said, sorry, I'm asking in regard to banking code of practice versus the customer-owned banking code. Have you guys, is that sort of answered? So then the next question is from Barry. Did the bank go after the broker about the propriety of the application?
I don't think the bank went after the broker. Yeah.
Okay.
The bank just mainly looks at if the customer raises a dispute. If you want to go after the broker, it might be a separate complaint after against the broker. Yeah.
Right. Okay. All right. Thanks. Okay, great. So that's all the questions we
No worries.
for now.
Okay, so we might just try, a bit conscious of time, but we just have 2 more broad areas to cover, so we're sort of nearly at the end of the presentation anyway. Okay, so bankruptcy. Bankruptcy is a big topic, so we'll touch briefly on some of the main considerations. It's an option of last resort, but can be an option that the client should consider. A family and domestic violence victim can consider bankruptcy when they're unable to afford to repay all their debts now or in the foreseeable future. They've tried unsuccessfully to dispute those debts, get released from them, or has had advice that this is unlikely to be successful or would not make enough of a difference to the overall situation, and the client has no assets to sell or other means of addressing their financial situation. And it should be noted that by filing a notice of intention to present a debtor's petition or a debtor's petition, you are acknowledging the debt. What if the partner is going bankrupt or has gone bankrupt, and how would this impact on the family and domestic violence victim? If there are assets, the client should consider a property settlement. A property settlement can be obtained after the partner's bankruptcy. However, it's best to do this as soon as possible and before they become bankrupt. The family and domestic violence victim should use a family lawyer where possible and be upfront to them about the matrimonial debts, as any transfers of property to themselves prior to the partner's bankruptcy would be scrutinized. The trustee in bankruptcy has the discretion to claw back if a transfer was disproportionate and seems to be done to defeat creditors. Often, the matrimonial home will be at risk when the partner goes bankrupt. The trustee in bankruptcy should give the family and domestic violence victim the opportunity to buy out the partner's share. Whether they can then keep the home may depend on whether they're able to refinance to buy out the partner. The second broad area that we will look at now is family violence and insurance. So insurers are subscribers to the General Insurance Code of Practice, which had an important update in 2020 to include provisions for vulnerable customers. See Section 92, where a person's vulnerability may be due to factors such as subsection E, family violence, and subsection K, financial distress. There is also a guide to helping customers affected by family violence, which complements the Code of Practice. See Section 95, where an insurer must now have a publicly available policy about how we will support you if you're affected by family violence. This policy will be published on our website. Very recently, the General Insurance Code of Practice had a further update, which came into effect on 5 October 2021. One of the updates is that the insurers must now publish a financial hardship policy on their website. I have set out when caseworkers may run into insurance issues. This is not an exhaustive list. So a couple of specific examples that we have seen include where it's a joint policy and the abusive ex-partner leaves and then returns and damages the property. When the abusive ex-partner contacts the insurer and changes the policy details to no longer covering the client's home or car, and then there's damage. We'll now look at a case study example of an insurance and family domestic violence problem and how we can help. Maria's story. Maria was in a financially abusive de facto relationship with Richard. They had 2 children and Maria is a stay-at-home mom. The parties separated and agreed Maria and the children live in the home. The matrimonial home and its home and contents insurance policy was in Richard's sole name. In 2020, there was a house fire. Maria and her children escaped to crisis accommodation. Richard claimed on the insurance policy to repair the home. However, he then refused to claim for temporary accommodation for Maria and the children. The insurer then refused to talk to Maria, saying that she wasn't a policyholder. How we helped Maria. We called the insurer and we argued that Maria was a third-party beneficiary under the policy, alternatively a tenant in the property, and also an equitable owner of the property, as it was the matrimonial home to which she had contributed. We also argued that to deny Maria the benefit would be for the insurer to assist in the furtherance of Richard's financial abuse towards her. And under its family and domestic violence policy, the insurer promises to recognize vulnerable customers, be flexible, and explore best options. Due to urgency, we lodged a complaint at AFCA. Maria was finally given accommodation in a 2-bedroom flat while longer-term accommodation was being found until the repairs could be completed. When to get specialist legal advice. We're going to finish up now with some situations when your client may wish to seek legal advice from our centre. So you may wish to call us together with your client, or you can also refer your client to Financial Rights Legal and they can call us themselves to obtain legal advice. Financial Rights Legal gives legal advice in consumer credit matters regulated by the National Consumer Credit Protection Act and general debt collection with the focus where there is a threat of bankruptcy proceedings. Call us for advice when your client is served with court documents, for example, a statement of claim for consumer credit matters, where external dispute resolution through AFCA may be an option. It should be noted that when the client has a civil dispute or disputes the debt and needs advice on whether they have a reasonable defense, Financial Rights cannot give this advice and would refer out to other services. We can advise generally when the debt appears to be more than 6 years old, so statute barred debt, appears the loan was unsuitable or shouldn't have been obtained in your client's name, a suitable arrangement with the creditor can't be reached, or if you or the client is contemplating lodging in AFCA. Call us for urgent legal advice if a default notice has issued, especially if on a mortgage, there is a default judgment, client is being garnished, client's assets or savings are being eroded quickly, court proceedings have commenced, any court orders you're unsure of, for example, writ for levy of property, notice to vacate, bankruptcy notice, creditor's petition, sequestration order has been made. And in addition, your client may also need to obtain their own family law advice. They may need to talk to a family lawyer about property settlement disputes, child custody, shared parenting, child support payments, apprehended violence orders and apprehended domestic violence orders, and divorce. Free help is available, such as a local community legal centre, a local legal aid office, police station, and ask for the family and domestic violence officer there, family law courts registry, free online fact sheets and booklets. For property settlements with assets involved or where the client may need a family law court order, the client would generally need to see a private practitioner. And we're finishing off now with some, we've put some links to resources there that we've referred to and that you might also find helpful.
Thanks, Beck. Yes, look, really those are, if you want to delve any deeper into any of the information that we've given today. A reminder there of the contact telephone lines if you do want to get in touch, and also that email address if you've got further inquiries. Obviously, we're right on the 60 minutes, so it may be that it's easier to send through a quick note and we can answer anything that you've got there. But yes, I'll pass back in case there are any further questions.
Thanks so much, Annabelle. I haven't had any other questions come in, but a few thank yous coming in. But I'm mindful that we are right on the time, but I did have one question that I thought I'd pop out there. So I noticed through the presentation that there was a reference in relation to the Banking Code of Practice that the banks will become aware of an issue if you tell us. And I'm interested to see how that interacts with their obligations around some of the signs that would tell them that they should have known that there was an issue. So I guess I'm just interested to understand how those two things kind of interact, if that makes sense.
Yes, Claire, I think that was the point you were raising about what ought to have been known as well as what was known, and you provided a list of issues like somebody going to a financial provider and not speaking English as a first language and not being offered a translator.
Look, I think
and
it largely really depends on, you know, like each individual set of circumstances. So I think they sort of come part and parcel. And yeah, sorry, could you just repeat the question again?
Sure. So I noticed under the Banking Code of Practice that banks basically will take a position that we'll become aware of issues of vulnerability if you tell us, is basically what it said, but that there are actually obligations on them in circumstances where they should know. So it's not just about if a client would tell them, I presume, it's also about things that they ought to know. So I guess I was just interested to see where the banks kind of tread that line.
Yeah, look, I think it's a difficult question to answer, only again because it really, like, it would depend on the evidence that is made available in those particular circumstances. So, you know, things like, did a person require an interpreter, or was there, you know, were there silences, or was the person fearful? It comes down to, you know, the people that were present at the time or at the inception of the loan or the credit contract. So does that sort of answer your question?
Yeah, it does.
Yeah. So I agree. Yeah, I agree with Claire. It's still possible to win cases, even if you haven't brought that up to that. Even if you haven't brought it to the bank before. If there were enough circumstances, it's still possible to win cases. But I guess in terms of the code of practice, if you are assisting a client and they're in financial hardship, and they haven't made contact with the bank before, it's in those circumstances where it can be really helpful to just call up with the client to the bank's disputes department, and then like you tell them that your client is undergoing this particular circumstance, and tell them that they should note that in the case to treat this customer with extra care. Yeah.
Great. Okay. Yep. That's very helpful. Thanks, guys. I'm sorry if that was a bit confusing, but it was just one of those things I picked up through the presentation that I thought was interesting to explore with you.
Yeah, no, very good question there. Very good question.
All right. So, look, there hasn't been any other questions come in while we've been chatting, but a few comments to say thank you so much on your fantastic presentation. Alexandra said she had no idea the service existed. So thank you very much. That's lovely feedback to have, Alexandra. Thank you. So I would like to add my note of thanks to Annabelle, Claire and Rebecca for joining us today to share so much interesting and informative information in this space. I think it's given the pressures that are coming through as a result of COVID, it's really fantastic to be able to have more people aware of these circumstances and also of your service. So thank you very much for being with us today. So we're coming to the end now. I just wanted to let you know that we will be putting a recording on the CLCQ website, as I said at the beginning, and that the materials will be available from our website. We'd encourage you to complete the survey that will be sent out as part of SurveyMonkey post the webinar. And also just wanted to remind everybody that there is another webinar, CLCQ webinar, coming up on the 24th of November, which is on emotional intelligence at work, self-regulation tips and strengths-based tools. So that will be another fantastic webinar. So try and catch that one if you can. So that's it for today. Thank you very much, everybody, for joining us, and we'll look forward to having you with us again another time. And thanks again to the team from Financial Rights.
Thank you.
Thanks so much.